Imagine buying a house. At the end of the long process, you receive a thick stack of papers and sign your name. That physical document, a deed, is your proof of permanent ownership. But how do you legally prove you own a piece of land if your ancestors lived there for thousands of years, before modern governments, filing cabinets, or paper deeds even existed? This chart visualizes the core of what courts call Aboriginal title. It is a constitutional recognition that an Indigenous group owned the land first and never signed it away. On the right, we have a tiny sliver representing about 150 years of modern property law. Stretching back to the left is a vastly longer, unbroken timeline of Indigenous presence. To win this title in a modern courtroom, Indigenous nations have to pass a strict legal test. They must prove they were the exclusive occupants of a specific territory at the exact historical moment the colonial government drew its boundary lines and claimed sovereignty. Proving a case without written records shifts the focus of the trial, forcing the legal system to rely on evidence that can't be stored in a standard filing cabinet. Take the Cowichan Nation on Canada's west coast. Recently, they went to court to claim ownership of an entire 200-square-kilometer island without a single traditional property deed to their name. Instead, they used a very different kind of record. This is a massive, ancient cedar tree deep in the island's forest. If you look closely at the trunk, you can see large, vertical scars. This diagram shows what those scars actually mean. Centuries ago, Indigenous ancestors carefully harvested strips of cedar bark to make clothing and canoes, taking just enough without killing the tree. As the tree kept growing, the new rings wrapped around the harvest site. Today, scientists can count those rings and pinpoint the exact year the bark was stripped. Now, let's zoom out from that single cross-section. When researchers mapped the island, they didn't just find a few of these scarred trees on the beach. They found thousands of them scattered deep inland, creating a massive, undeniable footprint of active, continuous land management. When presented with this data, the appeals court agreed. They ruled that these modified trees are a legitimate repository of history. By accepting living ecological markers as hard evidence instead of requiring written colonial documents, the legal system created a fair way to evaluate historical claims. Ecological evidence is just one part of the equation. In another recent legal victory involving the Cowichan Tribes, the courts relied heavily on a second type of non-written record, oral history. For generations, communities have passed down highly detailed spoken accounts of territorial boundaries and fishing practices. The Supreme Court mandated that these spoken histories must be treated with the exact same legal weight as a written colonial diary. Compiling all this evidence for trial is an exhausting process. Proving these cases often takes decades of litigation and costs millions of dollars in legal fees. That heavy toll has pushed governments and Indigenous groups toward an alternative path: direct, nation-to-nation negotiation. Decades of historical civil resistance, where communities stood on gravel logging roads to protect their forests, forced governments to the table. This is how the Haida Nation secured peaceful recognition of their title without a grueling trial. Whether the final decision comes from a judge's gavel or a signed treaty, these new evidentiary standards compel governments to legally acknowledge original ownership. In the past, court rulings strictly limited how much land could be returned. They used what lawyers called a postage stamp approach, recognizing ownership only over the tiny, exact physical footprints of historical village sites. This map shows how that is changing. Because courts now accept ecological and oral evidence, that tiny postage stamp of a village is expanding outward. The recognized title now covers the entire surrounding watershed, the forests, and the coastlines. We are seeing this happen on a massive scale. The new Talalot claimed entire islands, and the Haida Nation recently secured title to their entire archipelago. These recognized territories cover pristine coastlines and dense, old-growth forests, land containing vast amounts of natural resources. Recognizing that Indigenous people manage continuous landscapes rather than just isolated camps is actively redrawing the modern map of North America. This redrawn map brings us to a disruptive legal concept to emerge from these rulings. Aboriginal title is classified as a senior right. In places like Richmond, British Columbia, courts determined that Indigenous title actually predates and sits legally above modern private property deeds. To understand how a senior right works, look at this stack of documents. At the bottom is the Aboriginal title layer. Sitting above it is the original Leonardland issued by the colonial government. Because the government never had the right to give that land away, their layer cracks. On top sits the private property deed layer, resting completely on the defective government layer below it. Now, this does not mean everyday homeowners are facing eviction. The top layer remains protected. The legal debt is owed directly by the government that improperly granted the land in the first place. What makes a senior right so impactful is that it shatters the illusion that modern government property registries are absolute and unquestionable. Because the government's claim to the land was defective, there are now steep financial consequences for unauthorized wealth extraction on these territories. We can see this playing out globally. In Australia, courts are ordering mining corporations to pay tens of millions of dollars in compensation, specifically to address the intangible cultural and spiritual loss caused by heavy industrial use on Indigenous land. These legal victories represent a massive transfer of both governance power and financial capital back to Indigenous nations. The Aboriginal title movement is a profound legal correction, a global acknowledgement that the truest, most powerful deeds were never written on paper, but were recorded in the forests, the rivers, and the stories of the people who were always there.